I'm joined now by trial attorney and legal analyst, Misty Marris. Good morning to you. Thanks so much for being with us this morning. Let's talk about the jury instructions, because that's where the judge will start this morning, right? There was disagreement between both sides last week when they were talking about the jury instructions the jurors will get. Tell us why that's important and what they will likely hear from the judge.
Absolutely. The jury instructions are of critical importance. And the reason that that is the case is because it sets forth what the prosecution's burden is to establish every element of this case beyond a reasonable doubt. So in most cases, jury instructions in New York and in every state, there's what's called pattern instructions. And so it's pretty well known what the instructions are ultimately going to say by both the defense and the prosecution. But in this case, because of the way that this case is actually stacked, you have the falsification of business documents in furtherance of another crime. You have a New York State election law statute that also requires an unlawful act. And then we have campaign finance violations. These jury instructions are going to be quite complicated. So the first thing that will happen today is the judge will read the instructions to the jury. He will go through each of those elements and explain how what the jury needs to find in order to find Trump guilty or to determine that the prosecutors fulfill their burden. There was an all-out fight between the sides as to what these instructions would say, and today it will be revealed which side actually might have come out with some slight lead as far as what those jury instructions actually are going to tell the jury.
Well, can you help us understand what some of those disagreements were, like what, the defense did not want as a part of the jury instructions versus the prosecution?
Absolutely. And there's some critical things to listen for today as these jury instructions are unveiled. Number one, the prosecution wanted in the jury instructions for it to say that a retainer agreement is necessary in order to commence legal representation. This would be directly at odds with the defense argument that retainer agreement was accurate. Even though it was not reduced to writing, it existed verbally and therefore was sufficient. So the defense does not want that instruction in the argument, so they can argue that these documents were actually not falsified. Another area of that was contested, the intent to defraud. What does that jury instruction look like? Prosecutors want a very broad definition, while defense attorneys want to show that actually the intent to defraud has to relate to a pecuniary or property interest, not just a general intent to defraud with respect to the election. Another area, what does in furtherance of another crime mean? Intent to commit that other crime. So all of these different areas, including the federal election law violations, will have to be set forth. And there were strong disagreements about the language. Of course, prosecutors want it more broad. Defense wants it more narrow.
Wow. Okay, I'm trying to wrap my head around all of this. I mean, it seems like it's going to be a really tough few days or hours for the jury, including the jury instructions, because there has been so many hours of testimony. There's also evidence. I mean, is it going to be as simple, which I'm sure it's not, as it coming down to whether or not they believe the dueling narratives versus the paper trail in front of them?
I actually think they're going to grapple with these jury instructions. That's been my opinion. As an attorney, even hearing the arguments that were set forth, they are unique and they are quite complicated to understand how they apply. And, there's two lawyers on the jury who might really be leaders in that jury room. But look, if there is a juror who is going to scrap Michael Cohen's testimony, and again, the jury instructions will say, if you believe a witness lied about something material, you can disregard their testimony in total.
Wow.
You don't have to take it into consideration. That could certainly impact the case.
Yeah, it sure can. And especially because we had that dramatic moment with Michael Cohen on the stand and regarding that October 2016 call. We're going to have to leave it there. This was fascinating, Misty Marris. Thank you so much for your time.
Absolutely.